Sergeant, get your lieutenant, please.
That's what I said.
Sergeant?
But that wasn't me. Huh? I have it on a body cam downloaded.
Wait a minute.
All right, let's go ahead and call up the Dewitte cases.
State of Florida versus Jeremy Charles Dewitte, 2020 CF 4466, 2019 CF 12733. State.
James Knoll for the state of Florida, covering all cases.
Defense.
Amir Ladan on behalf of Mr. Dewitte, Your Honor. Good morning, good afternoon, or good morning.
Please raise your right hand. Do you solemnly swear affirm that the testimony you shall give to the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Good morning, sir. Tell me your name and your date of birth.
Jeremy Charles Dewitte, 21080, Your Honor.
All right, you can sit down, Mr. Dewitte.
Thank you, sir.
So in each of these cases, Mr. Dewitte previously entered pleas. There were split sentences involving a period of incarceration in the Department of Correction, followed by a period of supervision. And now there have been a number of allegations of violation. I think we're on the Fourth Amendment amended affidavit, or is there more than that, Mr. Ladan?
I think that's correct, Judge.
The case is set for a plea conference today. So, Mr. Ladan, what is it that you want to ask the court?
Sure. I think the background is as follows, as I understand it, and I think it's relevant for the court's consideration, so I'm going to start there. Mr. Dewitte had contacted me prior to the original violation being filed in November of last year, advising me that he was having some challenges with probation, indicating that he may need an extension of time on some of the requirements of him that he needed to execute as part of his plea agreement. Before I got a chance to fully vet and address those, a violation was filed on November 22nd before the court, in which probation was recommending a modification to community control, alleging a number of violations. On that same date, November 22nd of 22, a warrant was issued by Your Honor based on that violation of probation. On the 25th of November, I filed an emergency motion to recall that warrant, and in between the date of the VOP actually being filed and my client getting arrested, I popped in on the court on a couple of occasions, spoke with the then ASA on the case, and also, Your Honor was kind enough to address the case even though it wasn't on the docket, at which time I was inquiring as to Your Honor's willingness to recall the warrant, because at that time the prosecutor was amenable to recalling the warrant. Your Honor indicated you weren't willing to do that sight unseen, that you needed to review things, and at some point I think you indicated that we just needed to have a hearing. So we endeavored to do that. A motion to set bond was filed after he was arrested on November 29th, which kind of got ahead of me getting my hearing set and heard. And then an amended violation was filed the day after I filed my motion to set bond, alleging, among other things, that he was non-responsive to probation and or law enforcement coming to arrest him.
Let me interrupt you for 1 second.
Sure.
I may have misspoke. I'm only seeing a third affidavit. John, can you check on Mr. DeWitt and see if there's been any affidavits filed or addendums filed after what's the date of this?
I believe it was February 17th, 2023.
Jeremy Dewitte, you have your house surrounded. This is the Osceola County Sheriff's Office. Come out with your hands up now.
Keep going. Trying to send these
Jeremy
to Beauclair.
Dewitte, this is the Osceola County Sheriff's Office. Come out with your hands up now. You're good, you're good. Jeremy Dewitte, you have your house surrounded. This is the Osceola County Sheriff's
There's one on the
Come out
other
with
side,
your hands up now.
the other corner of the house.
We have spikes. You guys got spikes?
I do.
Hand them to me. Send me the spikes.
Jeremy Dewitte, the Osceola County Sheriff's Office. Come out with your hands up now.
Give me cover.
Right. Thank you, Mr. Knowlton. Yes. Is there anything else after February 17th? Okay.
That's the latest one that I have, Your Honor.
All right, so I misspoke. It was a third addendum, not a fourth. All right.
Well, there were representations made by prior prosecutors that other affidavits would be amended that never were. If you recall, I've been before the court several times when we were told another amendment was going to get filed and it never was, so I don't think it's unreasonable that we miscalculated. Regardless, the essence of the background is what I was kind of laying out for the court's consideration. And the reason I think it's relevant is that in speaking to our current prosecutor, the essence of the violations that they would be going forward on, I think, are narrowed down to the noncompliance when law enforcement was coming to effectuate the warrant. And as I've previously advised the court and the state, I was in communication with Mr. Dewitte, and I said, stand down. I may be able to get this done because of the representations that were made to me. I might be able to get it recalled. And so I don't want Mr. Dewitte to now suffer the consequence of my legal advice advising him to stand down while I was actively engaged in the endeavor to recall his warrants. So that's why I think that background and that timetable is relevant to the court's consideration, especially when you consider that at the time of the original VOP, probation's recommendation was, let's just put him on community control and work through what it is we're dealing with. To my knowledge, the substantive new law offenses that were previously alleged have been backtracked because I believe they were in, maybe not in violation of, but contrary to the plea agreement, which required that certain allegations not be brought forward. I do think there are potentially pending Osceola new law offenses that the state's not intending to go forward on if this was to go to a VOP hearing. And so the narrow kind of scope of what you'd be reviewing are whether or not he didn't comply with shutting down certain YouTube accounts and whatnot, which the state's not intending to go forward on. And I have, in my estimation, at least one, if not two witnesses, being my client's mother and another witness who would say that while he was incarcerated, they were endeavoring to shut things down and were just stonewalled because of an inability to recapture logins, passwords, and whatnot, but it wasn't any material or deliberate lack of effort on Mr. Dewitte's part. So, and I'll let the state correct me if I'm over-narrowing the scope of what they'd be presenting, because I don't want to misstate that, but I believe what I'm saying is accurate.
And Mr. Ledan, let me ask you this. Now that you've been working with Mr. Knowlton, is there a negotiated resolution where he admits to the narrowed violation and everything else goes away?
Well, that was what we had discussed in theory. My hope would be that Mr. Dewitte, having suffered the consequence of having sat in jail for a number of months now, lost his deposit on the schooling that he was endeavoring to do, that we could get him reinstated with some type of time served and continue on his way to effectuate the balance of the sentence. But we don't have an agreement in writing of any kind, and that's why I think we needed to plea conference the case today.
What's left off a sentence for him to do? I mean, he's got, regardless of what happens with this case, right, he's going to have certain requirements as a sexual offender he's going to have to comply with for the rest of his life.
Correct.
So as far as the sentence and the conditions of probation, right, what was left for him to do other than this issue of the YouTube videos? There was,
the probation officer believed that one of the vehicles that Mr. Dewitte had was a new and unregistered vehicle. It was actually one of the Metro State vehicles that had been taken, stripped of all of its whatnot, and repainted. I believe that's been registered correctly. I believe it's identified correctly. So to my knowledge, the only thing that needs to be done is paying financials and continuing on the term of the sentence. I don't think there's actual outstanding conditions as it relates to Metro State, and all those things have been remedied. So I'm unaware of any specific conditions that would have to be met.
Because candidly, given the history of this case, it doesn't seem like probation or community control is a great fit for Mr. Dewitte. You know, it appears potentially partly this is a relationship issue between how he gets along. I'm well aware that Mr. Dewitte has a number of detractors in the community who are highly interested in. I mean, my perception is if he's put back on supervision, that I'm just going to be dealing with another violation at some point in time. So I'll certainly listen to a discussion about putting him back on supervision, but it wouldn't appear to be my option A. So, Mr. Knowlton, let me ask you this. Is there a concrete offer to resolve the violations in these two cases? And if so, what is that concrete offer?
So, Judge, I'm aware of a previous offer made to Mr. Dewitte by the former prosecutor, which was 69.7 months Department of Corrections. On the score sheet the global score sheet, he does score 69.07 months Department of Corrections as the lowest permissible sentence according to the criminal code score sheet. Judge, may I approach with the criminal code score sheet?
Sure.
I have a copy for defense.
When you say the prior prosecutor, you're talking about Ms. Zeglin?
Yes, Judge.
Now, do you know where in the process that offer was made? And the reason I say that is because there were several occasions where Ms. Zeglin represented that there were going to be additional charges filed. Mr. Ledan did say that some of those charges he felt like were precluded by the plea in this case. So my question is, was her offer at that time based on the idea that these new offenses in Osceola were going to be prosecutable, and or the first or second addendum affidavits were going to be the affidavits proceeded on?
So, Judge, to my understanding, the basis of some of those Osceola cases occurred prior to Mr. Dewitte being placed on probation or being released from the Department of Corrections. For example, Mr. Dewitte has a pending case in this courtroom set for pretrial in July that additionally is not in the affidavit because it is the factual basis of it occurred prior to Mr. Dewitte being placed on supervision.
All right, so pause that thought. Mr. Ledan, is that a case that you believe can't be prosecuted because of the prior plea agreement?
The one that's now pending? I don't think I'm attorney of record on that case yet, and that's one that I haven't fully assessed, so I don't want to misspeak.
What's the charge in the new case pending in this division?
Judge, the new charge is, as filed, from what I'm aware of, is organizing or planning motor vehicle collision and several counts of false or fraudulent motor vehicle insurance application, as well as, I believe there was in culmination with that, sex offender violation for failure to register a motor vehicle, and a false or fraudulent insurance claim of greater than $20,000. But again, these are factual circumstances that occur.
I understand that. So again, my question is, do you agree that at this point in time, the only allegations that you think you would prove at hearing are the non-compliance allegations?
Correct, Judge. Pursuant to the third affidavit for violation of probation, if this were to proceed to hearing today, and there wasn't another amended violation filed, which I don't have any information that there will be one, the state would be proceeding on violations A and violations B of the third affidavit, which are the technical violations, Judge. What's concerning now, Judge, is that from what I've heard from the defense counsel, there's been statements that Mr. Dewitte was under advisement. Obviously, that might be a defense to these violations. So there's concerning conflict, Judge, between defense counsel and the defendant now. The state has concerns regarding whether or not that can be brought to a violation hearing because the state would want to know what those advisements were.
Well, if he advances that argument at hearing, he would need to offer evidence in support of that. So I don't know that that would be a legal defense to the alleged violation. So, Mr. Dalton, I'm still wondering, understanding that those are the only allegations you believe you can prove at hearing, what's your offer today to resolve those violations given the history of this case?
Judge, my offer would be the lowest permissible sentence in the criminal case score sheet, which would be 69.07 months in Department of Corrections.
Was the original sentence a departure, Mr. Levan?
It was. It was a departure, and it was part of the reason that Mr. Dewitte contemplated taking the deal to begin with.
And what, Mr. Levan, understanding that option A is not, in the court's mind, is not a reinstatement. I'm not saying that's completely off the table. I just foresee that it's probably not actually in your client's best interest to go back on supervision at this point. What's your option B that you would ask the court to do?
Your Honor, my challenge is that his wife is back in the hospital and they have a minor child that's under the age of 4. She's 2, with no other family in town. So I'm hopeful that we can find an option, 1A or something that would allow him to be on supervision to assist there. I don't know what alternative there would be unless you're considering a time served sentence and revoking and terminating his probation and letting us, deal with whatever these new law offenses are as standalone issues on their own face. I mean, he's been in continuous custody for several months now. The purpose of the sentence, I believe, has been effectuated. So if the court would be willing to consider a downward and time served, I'm certainly not going to argue against that. I think.
Well, I'm not necessarily assuming time serves the equation. I do have a question for the clerk about that. It just seems like the kind of case where the appropriate outcome is just the appropriate period of incarceration, revoke and terminate. He can deal with the new case when the question is what's, quote unquote, an appropriate amount of incarceration. So, Madam Clerk, here's what I'd like to know. You're showing that he's got 302 days in the Orange County Jail. Can you break that down to me for what he had at the time of his original plea?
So his original time served on both cases was 110 days. And then he had an out-of-county arrest for this violation that began on April 29th of 2022 and until today, 192 days.
Okay.
He also did DOC time. I don't know where that's kind of coming into play.
No, I get that. He's entitled to that time. What I'm trying to figure out, basically what I was trying to figure out in my mind is.
Was that on a different case?
No, this was a split sentence.
Okay. Let me look further into that then because someone else worked with this.
He was sentenced to DOC. It was less than the lowest permissible. It was a departure, but it was a split sentence. So what I'm trying to figure out is since he got out of DOC, how many days has he served because of the violations in this case? And it looks like 192. Since the violation.
Yeah, he was picked up November 28th or November 27th. So we've got at a minimum those 6-ish months from that date forward.
Madam Clerk, let me break this down. Is he contesting the 110 on the front end that he had when he originally?
No, I think that's what he was given at the time of sentencing.
All right. So what's the date, Madam Clerk, that you're using for when he started earning additional Orange County jail time?
11/29/22. But I'm looking at where he was originally pled, and there was not DOC time. It was 110 days in Orange County jail with credit for 110 days. On the 4466, I'm going to continue looking into the other cases.
I've got the plea form up in front of me, Judge, just to make it simple.
Which case then?
2020 CF 4466. He was sentenced to 366 days in DOC, followed by 2 years. That's what I'm looking at here.
I do say that it does say to run consecutive to his Department of Correction sentences on other cases. So.
Right.
Neither of these were consecutive to his DOC time, but they didn't actually contain DOC time for these two cases.
How many cases did he close at the time of sentencing?
5, I think.
Was this a situation where he got the DOC time on certain cases and then he got supervision on other cases?
It's possible, Judge, but the plea I'm looking at, for example, in 4466 is a split sentence that contemplated both. So.
Judge, in my count, I believe there's about 8 cases that were resolved.
The sentencing paperwork on 4466 is 110 days in the Orange County Jail, credit for 110 days time served, sentence to run concurrent with each count, and probation sentences on cases 19 CF 12733 and 20 CF 4466. This sentence is run consecutive to the Department of Corrections sentences in 19 CF 15055, 19 CF 15056, 20 CF 1977, 20 CF 2414. So the way the sentencing paperwork reflects is these sentences were probationary sentences running consecutive to the DOC time he got on other cases.
Okay. I'm reading the plea form that I executed with him, so it may have been announced one way and then sentenced a different way.
And it's also within the realm of possibility that what was said in open court is not exactly what was reported in the sentencing paperwork.
Yeah. That happens. At the time of the resolution of that case, the prosecutor and I had come up to this point based on the fact that they wanted a DOC sentence, and so it was a year and a day, downward departure, and supervision to follow. The primary purpose of the sentence was to ensure that he wasn't engaging in business any longer, and that he divested himself of the company.
Let me ask you this, Mr. Ledan. Do you want time to go back and actually listen to what was said at the sentencing and determine if there's an error in the paperwork? Or is that not how Mr. Dewitte wants to proceed?
Let's find out what the judge.
By next Friday, if I'm not home by next Friday, you're going to start the foreclosure on my house.
I don't know if he's going to let you out today, dude, so stop thinking about it from that perspective. Do you want me to go back and listen to the record? Do you think the sentence that the judge is reviewing was improper or inaccurate?
No, that's right. It was not. It was the probation after Department of Corrections.
Okay.
But the thing is, I didn't violate.
Yeah.
You know what I'm saying?
Hey, well, we're not going to get into that argument right now. Okay. Do you want to listen to the recording or not?
No.
Okay.
Your Honor.
It's our understanding that this was the sentence as stated. I don't think I need to go back and listen to the recording.
Based on what I've heard at this point in time, if he wanted to resolve the case today, I'd sentence him to 365 days in the Orange County Jail with credit for 302 on each case, revoke and terminate, and send him on his way. He can deal with his other case when it gets done. That would be continuing the departure sentence. I know the state's objecting to that, but given the allegation that the only violation the state thinks he'd be able to prove is that he basically didn't open the door and let the probation officer come in. I am aware that there were efforts underway to quash the warrant. And my understanding is that's the reason they wanted to come in, is they wanted to actually serve the warrant. I consider that a mitigating factor. I don't necessarily consider it a defense to the violation, but I certainly consider it a mitigating factor. So if he wants to resolve it that way, that's fine. If he wants to get set for hearing, we'll set him for hearing.
I just need a moment to review a plea agreement, Judge. I anticipate that'll resolve it.
All right.
Thank you, Judge.
All right. Let's shift gears.
Huh?
Anyways,
Hey, it's the sheriff's office. Stop! Stop right there! No, stand up!
He's coming out. He's in the front of the house. He's in the front of the house. He's walking out to the deputy's family.
Keep walking. Stop! Stop!
All right. He's on his knees.
They already arrested me, Rania. No, they're saying it's me, but it's not fucking me.
Let's recall the Dewitte cases.
Recalling State of Florida versus Jeremy Charles Dewitte, 2020 CF 4466, 2019 CF 12733. State. Defense.
Amir Ledan on behalf of Mr. Dewitte.
Mr. Dewitte's already been sworn in. Mr. Ledan, how does Mr. Dewitte want to proceed in regards to these two violations?
Your Honor, in both 2020 CF 4466 AO and 2019 CF 12733 AO, Mr. Dewitte's admitting a violation of Condition B in that he did not respond as required to probation when called upon. I've reviewed with him the admission indicating that he's entering a best interest plea in exchange for which he's going to have probation revoked and terminated. They'll be sentenced to a downward departure of 365 days in Orange County Jail with credit for 305 days. I have reviewed this with him. Mr. Dewitte does take some heart medications, but nothing that would affect his ability to understand this. And I've been dealing with Mr. Dewitte for many years. He's very clear-minded, and I can tell he's in a condition to accept and understand this plea agreement. It's not executed by the state because it's not a negotiated plea. May I approach?
You may. And Mr. Knowlton, you're not proceeding on the other allegations, correct?
Judge, violations of Condition E, the state doesn't have. So I believe I misspoke earlier. It's not that they occurred prior to probation. It was that the state didn't have discovery for those. They are unfiled Osceola County cases, and the state just wouldn't be able to prove them in a violation of probation.
He's admitting to a single allegation of violation. And I want to make sure I understand correctly. You're not proceeding on any other allegations of violation. Is that correct?
The state would be proceeding on violation A.
I didn't see violation A, but certainly, can you articulate what that is real quick?
Violation A of special condition of order of probation by failing to comply with all instructions given to him by the court as grounds for belief the offender violated his probation. Officer James Woods states that on 9/21/2022, the offender was instructed to permanently close the lead official Metro State YouTube channel and provide proof of probation.
So my understanding is you were not proceeding on that allegation, correct? Mr. Knowlton?
That is correct, Judge.
So, again, here's what I'm trying to avoid. He admits to one allegation of violation. I sentence him, and some judge down the road, for some reason this case gets called back up, and the record is silent as to what happened to the rest of the allegations.
No, I'm sorry, Judge. So it is the second part of A. It's violation of special condition of order of probation by failing to follow the rules of electronic monitoring and as grounds for belief that the offender violated his probation. Officer James Woods states that on 11/29/2022, the offender refused to follow the rules of electronic monitoring by failing to enter the tracking device and follow instructions given to him by the probation officer.
Mr. DeWitt admits to that, Judge, and the net effect is once you revoke his probation, the case is closed.
Try one more time. That's what he's admitting to. As to any other allegations pending, you're not proceeding on any other allegations pending, correct?
That and count and allegation B.
Which he's admitted to.
Okay, fine.
And there are no other allegations that the state would proceed, would be proceeding on, Judge.
Okay.
For which conditions is he admitting?
Special condition that he did not comply with their GPS tracking requirements in some material way, and condition B. It's a special condition. I think Mr. Knowlton might be referring to it as a condition A, but when I read it, it doesn't say condition A. It just says a special condition. So I'm happy to call it whatever it needs to be called, but that's what it is.
Well, now I'm going to go look it up.
I may not be reading it.
There's a higher than average possibility that someone may want to comb through this case. I want it clean.
So, Judge, it doesn't say condition A. It's just a special condition.
So he's admitting to the condition B violation and the special condition violation of GPS monitoring.
Correct.
Okay.
Correct.
All others are going to be dismissed in return for this admission. Mr. DeWitt, is this how you want to resolve your case?
Yes, Your Honor.
As you sit here today, are you under the influence of any drugs, alcohol, or other medication?
No, Your Honor, sir.
Have you ever been treated for a mental illness, emotional disturbance, or are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes, sir.
Your attorney has given me a document called a Violation of Probation admission form. I'm holding it up. Does this look familiar to you?
Yes, Your Honor.
Did you go over this form with Mr. Ledan?
Yes, Your Honor.
Did he explain to you all the rights you have and the rights you give up when you admit you violated your probation?
He did, sir.
Did he answer any questions you had about your rights?
Yes, sir.
Did you then go through the form initially and then signing the form?
Yes, Your Honor.
Do you understand that we are not going to have, by entering this admission, we're not going to have a hearing in your case, and I'm going to sentence you today?
Yes, Your Honor.
Has anyone forced, threatened, or coerced you to make this admission?
No, Your Honor.
other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you would receive?
No, Your Honor.
Now, specifically, apparently you've got another case pending in this division. Do you understand that the disposition of this violation in no way is binding the state's hands or the court in regards to what happens with your next case? Do you understand that?
Yes, Your Honor.
Are you satisfied with the work Mr. Ledan's done in handling your case?
Very, always.
Looks like he's done a great job for you, sir.
Yes, Your Honor.
Do you understand, sir, if you were not a citizen of the United States, entry of this admission would result in your deportation?
Yes, sir.
Mr. Ledan, are you conceding that the affidavits of violation set out a factual basis for the Condition B violation and the special condition violation in regards to GPS monitoring?
We do concede and stipulate, Your Honor.
Sir, I'm going to accept your admissions. I find your alert, intelligent, your admissions are freely and voluntarily entered. You understand the nature of the crimes you're charged with, represented by competent counsel, whom you say you're satisfied, and I do find a factual basis based on the affidavits filed in each case. In each case, I'm going to adjudicate you guilty. In each case, I'm going to revoke and terminate your probation. In each case, as to each count you were on supervision for, I will sentence you to 365 days in the Orange County Jail. On each case, I'm going to give you credit for 302 days time served.
I may have heard you wrong the first time, Judge. I thought it was 305. So I wrote 305 on the document because I thought that's what was announced. So I may have heard it wrong.
Clerk told me 302.
Okay.
So it's 350 on each case, each count 365, 302. All counts are concurrent and cases are concurrent with each other. This is a departure sentence. I'm going to continue the departure the state originally agreed to when they pled this case out in the beginning based on the actual allegations of violation that he's admitted to and the facts, as I understand them, surrounding how those violations took place. I will order the defendant pay all statutorily required fines, fees, and costs associated with this violation, along with whatever unpaid balance remains on these cases. Madam Clerk, can you announce it by case number?
Yes, Your Honor. In the case ending in 4466, there's a previous balance of $518, $100 state prosecution fee for a total of $618. In the case ending in 12733, there's a balance of $499, $100 state prosecution fee for a total of $599 for a total of $1,217.
Mr. DeWitt, if I gave you 18 months from your date of release, is that enough time to pay all those costs off?
Yes, Your Honor.
Listen carefully. Or you pay your cost in full within 18 months of today's date, or in the alternative, within 60 days of your release from custody. If you want to go on a payment plan, report to the clerk's office, room 410. Fill out the paperwork to go on a payment plan. I don't object to you consolidating the cost on these two cases into a single payment plan. Madam Clerk, do you need anything else for your paperwork?
No, Your Honor.
Mr. Ledan, anything else?
Your Honor, previously Mr. DeWitt has been found not to be a violent felony offender of special concern, and that's been documented, but I don't know if you have to make another finding of that yet again in this case.
Which of his charges that were before the court actually, well, let me see his score sheet again.
Well, that was what prevented us from getting him bonded to begin with. Is they keep hearing.
No, the law does require me to conduct a danger hearing. Mr. Knowlton, are you going to argue the defendant's currently a danger to the community? And if so, what evidence are you going to present on that matter?
Judge, the state would argue that the defendant's a danger to the community based on the statutory factors. The offender's present conduct, including his criminal history, as provided in the criminal code score sheet that is under review by Your Honor, as well as the defendant's history shows a lack of amenability to non-incarcerative sanctions based on his history, falsely impersonating police officers, several violations of probation, and failure to register as a sex offender on multiple occasions. Any other facts that Your Honor deems as relevant can be considered by Your Honor throughout the affidavit, as well as anything that the court deems relevant, Judge. But I believe based on the history, Judge, I believe it is indicative of Mr. Dewitte being not conducive to non-incarcerative sanctions, specifically non-downward departures, Judge. But however, from my understanding, under Martinez v. State 103 Southern 3rd 1013, Your Honor is able to make a determination about whether or not the defendant is a danger to the community, and Your Honor determines that he's not a danger to the community, then Your Honor can revoke and term modify probation or go along with the state's previous downward departure. However, if Your Honor finds the defendant is a danger to the community, under the statutory guidelines, under several cases, specifically I believe it's Whitaker v. State 223 Southern 3rd 270. Your Honor, 223 Southern 3rd 270, which outlines, which is a case about downward departures. I believe Your Honor is able, if Your Honor, basically, Judge, if Your Honor finds that he's a danger to the community and makes a determination that he's a danger to the community, then, and continues a downward departure sentence, then Your Honor is required to make written findings with regards to whether or not the statutory factors that the court considered in making that downward departure. If Your Honor does not determine the defendant is a danger to the community, Your Honor, I don't believe is required to do that. However, I believe Martinez, it is Whitaker that states that if the defendant qualified as a violent felony offender of special concern, despite the fact that the trial court in a probation violation proceeding found the defendant not to be a danger to the community, where the defendant was on felony probation for aggravated battery with a deadly weapon, I don't believe you would be required to make written findings, Judge, if you found him not in a danger to the community.
All right. So while I do agree that the defendant's prior criminal history and the underlying facts of the case are a factor to consider, I've also considered the violations in this case stem from initially failure to close a YouTube website. Once that violation was in place, then the subsequent conduct that led to this violation surrounded the effort for the probation officer working with Osceola law enforcement to secure the defendant on the warrant the court had signed. While he didn't comply with their request, there was no evidence that he offered violence to any of the probation officer or anyone else. So for those reasons, I don't find that he currently poses a danger to the community, and the sentence will remain as I previously announced. That is, go ahead.
No, sorry.
That's the judgment, and since the court, Mr. Dewitte will be returned to the Orange County Jail to serve the balance of his sentence.
Now that that's done, Judge, although I'm not attorney of record on the new law offense pending before Your Honor, Mr. Dewitte did want me to inquire whether the court would have any objection to reducing the bonds in that case so that he might be in a position to be transported. He's not going to get out. He'd have to, once he posts bond in this case, he has to be transported to Osceola County to then go for an initial appearance before a judge on that warrant. And so the inquiry was whether or not the court would be reducing your bonds without.
I know nothing about that case. It's not docketed for today, and I'm going to start death penalty litigation this afternoon. So I need to shift gears. So I won't address that at this point in time. I think potentially it needs to be addressed in front of the Osceola County judge. If it's an Osceola County case? No,
it's the case before, Your Honor, that he wanted to have the bond reduced. But I explained that that's not on the docket, and I'm not of record, but as a friend of the court and certainly
file it. If you're going to get in the case, file a motion. Yep. The state should have an opportunity to respond. I'm not sure the prosecutor is. So that's not a matter for today.
That's what I advised him, but I thought I'd give it a shot.
Sure.
Thank you, Judge.
All right. We're in recess till 1:30.
Yeah, it's my guys. It's one of my guys. Today. And that's not fucking me yelling at that guy. And that's why I know we're doing the escorts right. Whoever that fucking was, that doesn't make any sense.